Breaking news, a critical test in the criminal cases against two of President Trump's biggest political foes. A federal judge in Virginia just heard arguments in a bid from James Comey and Letitia James to disqualify prosecutor Lindsay Halligan. Their attorneys argue Halligan was handpicked by President Trump and is serving as interim U.S. attorney for the Eastern District of Virginia unlawfully.
The Trump defense team, when Donald Trump was a criminal defendant, he had won his case by having the prosecutor Jack Smith tossed off of it in Florida in a set of arguments very similar to this. And Judge Curry is now asking the Justice Department, are you guys against that now?
Hey guys, Sophia is here. So what just happened is absolutely significant. Trump has spent years selling his supporters on the idea that he dominates courtrooms, that judges respond to his presence, and that his legal battles are showcases of his strength. But what millions just watched inside that Manhattan courtroom was the direct collision between that image and reality.
Judge saying, Mr. Kais, please control your client. Trump saying, Your Honor, look, I did nothing wrong. They should pay me for what we had to go through, what they've done to me reputationally, and everything else. So his lawyers in their closings were making the pitch that the Attorney General's team did not put on one witness who said that they felt that a fraud was committed here from the banks that had given them loans or the insurers that had underwritten some of these policies.
It was a 6-minute episode that ended with the judge telling Trump's own attorney to get his client under control, then cutting him off entirely and bringing the gavel down on the whole spectacle. Before we continue, please support us by subscribing to our channel and liking this video so that you will not miss any of our upcoming videos. The judge was visibly frustrated with Trump repeatedly during the course of his testimony. He urged Trump's lawyers to get their client to answer yes or no to yes or no questions. And at one point, Judge Engoron warned Trump's legal team that if Trump did not change his conduct in the courtroom in terms of how he answered questions, the judge would draw negative inferences when it came to determining the scope of the penalty in this ongoing civil case.
Say, quote, in the coming weeks. They mainly wanted to get this joint statement out to show, quote, a unified view on trade. And as you kind of laid it out, this is just the next procedural step. As you remember, President Trump and the EU Commission President Ursula von der Leyen kind of made that handshake, as you saw on screen, while the president was in Scotland. But now we're getting some of the further details on that. While the European Union has to introduce legislation to lower these tariffs, there will still be a 27.5% tariff on cars from Europe. That will stay until the tariffs on American goods are lowered, and that will reduce to 15%.
Let me set the stage properly because the context here is essential for understanding why this confrontation mattered as much as it did. This was the closing argument phase of the New York civil fraud trial, the case that struck at the very heart of Trump's carefully cultivated business persona. The allegations involved systematic inflation of asset values, the kind of financial misrepresentation that built the Trump brand over decades. A New York judge is now ruling that former President Donald Trump committed fraud and misrepresented his net worth for years. And according to the court documents just received, Mr. Trump apparently lied to banks and insurers, exaggerating his net worth by something in the range of billions of dollars.
The civil fraud case against former President Trump, his two sons and associates begins tomorrow in Lower Manhattan. It could mean Trump is out of business in the city that catapulted him to the presidency. CBS 2's Lisa Rosner has the latest from outside the courthouse. Lisa?
Well, Jessica, sources tell CBS News that Trump expects to attend at least Monday's proceedings. Trump is accused of inflating the values of his properties, which he denies. Opening statements begin Monday morning in the civil fraud case brought against former President Donald Trump and his sons Don Jr. and Eric by State Attorney General Letitia James.
So the judge is basically saying that the Attorney General for the state of New York, Letitia James, came forward with a civil complaint last year and said that the former president, through his businesses and his personal financial representations, committed fraud by overstating his personal wealth and the wealth of his properties. The stakes were enormous, not just financially, but existentially, for a man whose entire identity rests on the proposition that he is a brilliant businessman whose net worth is exactly what he says it is.
Donald Trump engaged in deceptive business practices and tremendous fraud. Donald Trump falsely, knowingly, inflated his net worth by billions of dollars to unjustly enrich himself, his family, and to cheat the system. Donald Trump may have authored the art of the deal, but he perfected the art of the steal. This long-running fraud was intentional, egregious, illegal, and he did all of this with the help of the other defendants, his 2 adult sons and senior executives at the Trump Organization.
Trump wanted to deliver his own closing argument. That was his demand. He wanted to stand before the court and address the judge directly, to make his case not through the careful procedural mechanisms of legal representation, but through the direct channel of his own voice. The request itself was unusual. Defendants in civil trials do not typically deliver their own closing statements. That is what lawyers are for. But Trump is not a typical defendant, and his legal strategy throughout these proceedings has consistently blurred the line between courtroom advocacy and political theater.
Former US President Donald Trump is calling a civil fraud trial against him and his company as a scam and a sham. The former US president and his 2 sons are facing claims in a New York court that they inflated their assets by almost $3 billion.
He didn't have to turn up to this. The fact that he chose to place himself at the center of the frame.
Thank you very much.
Well, that tells you everything about the state of American politics right now, because this is his campaign trail.
Fireworks in the courtroom. Donald Trump delivered his own closing argument in his Manhattan civil fraud trial today. Facing the prospect of losing control of his namesake company and a massive civil penalty, Mr. Trump briefly took matters into his own hands, declaring himself an innocent man and delivering a lengthy speech largely consisting of grievances against the New York Attorney General and the judge overseeing the case, whom he accused of having his own agenda. All of that forced Judge Arthur Engoron, who had previously resisted granting the former president permission to speak during closings, to tell Mr. Trump's attorneys to, quote, control their client. They do not have any evidence against us. Millions and millions of pages, years of litigation, and all politically motivated. The scene in court today played out just hours after police responded to a bomb threat at Judge Engoron's home. Judge Engoron was willing to consider Trump's request to speak. He did not reject it outright, but he imposed a condition, the same condition that any judge would impose on any defendant seeking to address the court directly. Trump's legal team had to promise that their client would stick to the law and the evidence. No campaign speeches, no political statements, no introduction of new material that had not been presented during the trial. Just the facts of the case and the relevant legal standards applied to those facts. This is where everything began to unravel before Trump ever opened his mouth. His lawyers would not make that promise. Think about what that means. The attorneys representing the former president of the United States in a civil fraud trial, officers of the court bound by ethical obligations of candor and professionalism, could not assure the judge that their client would follow basic courtroom procedure if permitted to speak. They knew what he was going to do. They knew he could not contain himself within the boundaries the judge had set. And rather than give their word and watch him break it, they refused to give their word at all. The judge accordingly denied the request for Trump to deliver a formal closing statement. The lawyers would handle the closings as lawyers do in virtually every civil trial in every courtroom in America. That should have been the end of it. The traditional closings proceeded. The legal arguments were made. The case moved toward its conclusion. But Trump's team was not finished. Attorney Christopher Kisei rose and asked the judge once more to let his client speak. It was a second attempt at something that had already been denied, a procedural request that put the judge in the position of having to engage directly with the defendant about what he would and would not be permitted to do. Judge Engoron turned to Trump and asked him directly if he would follow the guidelines that apply to every closing argument in every courtroom in this country. Trump's response was immediate, and it was not an answer to the question that had been asked. He launched directly into a statement about political persecution. He announced that he was an innocent man being targeted by forces that wanted to destroy him. He declared to the judge's face that the entire proceeding was a fraud on him. And then, In a moment of open condescension, directed at the man wearing the judicial robe, he looked at Judge Engoron and said the words that will follow him through every remaining legal proceeding he faces. I know this is boring to you. Sit with those words for a moment. A sitting judge presiding over a complex civil trial being told by the defendant that the proceedings are boring to him, as if the judge were a student nodding off in a lecture hall rather than a judicial officer exercising the authority of the state of New York. The condescension was personal. The dismissal was direct, and it was aimed at the one person in that room with the power to shut the entire performance down, which is exactly what happened next. Judge Engoron did not debate Trump. He did not engage with the substance of the statement. He did not try to reason with the defendant who had just demonstrated that he had no intention of being reasonable. He turned to Trump's attorney, Christopher Keyes, and delivered a directive that every lawyer in that courtroom understood immediately. Control your client. 4 words that say everything about what had just transpired. Control your client. Please speak with your client. Perhaps your client might benefit from a recess. The implication was unmistakable. The judge had identified a situation that was spinning beyond the bounds of acceptable courtroom conduct, and he was placing the responsibility for reining it in squarely on the shoulders of the attorney whose professional obligation it was to do so. Then the judge imposed a time limit. 1 minute. Trump had 1 minute remaining before the court would break for lunch. 1 minute to wrap up whatever he thought he was accomplishing. 1 minute before the gavel came down and the room went quiet. And the defendant who had spent his entire public life insisting that he could talk his way out of anything was told that his time was up. When that minute expired, Judge Engoron cut him off, not gently, not with an apology for the inconvenience of judicial procedure. He cut him off and recessed the court. The proceeding ended because the defendant had made it impossible to continue without compromising the basic standards of order and respect that American courtrooms require to function. The judge did what judges do when defendants refuse to follow the rules. He stopped the proceeding and he left the room. What happened next is just as revealing as what happened inside the courtroom. Trump had a choice. He could stay for the afternoon session. He could demonstrate that despite the confrontation, despite the judicial shutdown, he respected the institution enough to remain present for the remainder of the day's proceedings. That is what defendants do in ordinary cases. They stay. They sit through the parts that are not about them. They show the court that they take the process seriously, even when it does not go their way. Trump did the opposite. He skipped the afternoon session entirely. He simply did not return to the courtroom. Instead, he walked to a nearby building he happens to own and held a press conference. Standing before cameras he controlled in a setting he controlled, he proceeded to attack everyone involved in the case. He attacked Judge Engoron. He attacked New York Attorney General Letitia James, the single greatest witch hunt of all time. We have a judge who rules that properties are worth a tiny fraction of what they actually are. We have an attorney general who ran on the basis that she was going to get Trump before she even knew anything about me. The press conference was the courtroom statement continued by other means, a political counterstrike designed to reframe the day's events as righteous indignation rather than procedural defeat. The pattern here is not subtle. When the courtroom imposes limits, Trump seeks a more favorable venue. When judges demand compliance with rules, Trump attacks the judges. When the gavel comes down and the proceeding ends, Trump finds a microphone and an audience that will not cut him off after 1 minute. The sequence from courtroom to press conference, from judicial accountability to political counterattack, has become so familiar that it now constitutes its own pattern in Trump's legal strategy. But the strategy has a fundamental weakness that the Engoron confrontation exposed. The judge controls the courtroom. The judge decides when the defendant speaks and when the defendant stops speaking. The judge can direct attorneys to control their clients. The judge can impose time limits. The judge can recess the proceedings and walk out of the room, and none of that authority is subject to appeal in the moment. The defendant either complies or the defendant faces consequences. And on this particular day, the consequences were public, visible, and significant. The broader context of Trump's relationship with the judiciary makes Judge Engoron's response even more noteworthy because it is not an isolated incident. It is part of a documented pattern of attacking judges who rule against him, a pattern that extends from lower trial courts to the highest court in the land. Trump has called judges lunatics. He has called them monsters. He has used the term Trump deranged to dismiss any judicial ruling that does not go his way. He has used court losses as fundraising appeals and rally material, transforming legal defeats into political grievances in a way that no previous American political figure has attempted at this scale. The most revealing dimension of this pattern may be his treatment of the judges he himself appointed. When the Supreme Court ruled against his tariff powers in a significant case, Trump did not respond with measured disappointment in a decision he disagreed with. He called the justices who ruled against him a disgrace. He said he was absolutely ashamed of them. These are his own appointees, judges he selected and elevated to lifetime positions on the highest court in the country. And when they exercised their independent judgment in a way he did not like, he attacked them with the same vocabulary he uses for his political opponents. Think about the implications of that for American institutional culture. The president appoints judges. Those judges take an oath to administer justice impartially. They are not supposed to be extensions of the president's political will. They are supposed to be independent arbiters of the law. When the president who appointed them turns around and calls them a disgrace for ruling against him, he is sending a message not just to those particular justices, but to every judge in the federal system. The message is simple and damaging. Loyalty to me is the only standard that matters. If you rule against me, I will attack you regardless of your qualifications, your reasoning, or your relationship to my own administration. This message echoes through the Engoron confrontation because it establishes the baseline from which Trump approaches every judicial interaction. He does not walk into courtrooms believing that judges deserve respect by virtue of their office. He does not accept that procedural rules are legitimate constraints on his behavior. He views the courtroom as another arena for political combat, and the judge is either an ally to be cultivated or an opponent to be challenged. Judge Engoron, by imposing and enforcing standard courtroom procedures, demonstrated that the institutional architecture of American law still has the capacity to impose consequences on defendants who refuse to follow its rules. The implications for American courtroom culture are significant and worth examining. The legal system depends on a baseline of mutual respect between participants. Judges rely on defendants and attorneys to adhere to procedural norms without requiring constant enforcement. When a prominent defendant systematically refuses to adhere to those norms and is rewarded with political support for doing so, it weakens the informal mechanisms that make the system function. Every time a defendant turns a courtroom into a political venue and faces no meaningful consequences beyond a momentary judicial intervention, it becomes slightly more acceptable for the next defendant to attempt the same. The clash between rally-style behavior and courtroom procedure is perhaps the central tension of Trump's entire legal saga. The skills that work in a political rally, the improvisational rhetoric, the personal attacks on perceived opponents, the willingness to say things that traditional politicians would never say, are the exact opposite of the skills that work in a courtroom. Courtrooms demand precision. They demand adherence to evidence. They demand respect for procedural boundaries. A defendant who treats a judge like a political opponent and a trial like a campaign event is a defendant who is fundamentally incompatible with the requirements of the legal system. Judge Engoron's response, the control your client directive, the 1-minute warning, the ultimate shutdown and recess, represents the institutional answer to that incompatibility. The institution says there are limits. The institution says the defendant does not get to run the room. The institution says when behavior crosses a line, the proceeding stops. Whether that institutional answer is sufficient to deter future misconduct remains an open question. But on that day, in that specific courtroom, the institution held. In the aftermath of the Engoron confrontation, genuinely important questions arise about how far Trump is willing to go in challenging the courts if his legal proceedings continue to produce negative outcomes. The civil fraud trial was one front in a multi-front legal situation that encompasses criminal cases and civil cases across multiple jurisdictions. In each of those proceedings, Trump faces the same strategic choice: accept the legitimacy of the process and participate according to its rules, or challenge the process as illegitimate and rally political support against it. The Engoron confrontation suggests that he has chosen the second path, and that he will continue choosing it even when it produces public judicial interventions. The defenders of this approach will make arguments that deserve to be acknowledged. They will say that defendants in high-stakes cases sometimes legitimately express frustration with proceedings they believe to be unfair. That is true. The legal system is not perfect, and defendants are not required to be completely emotionless. They will say that judicial decisions sometimes reflect perspectives that deserve criticism. That is also true. Judges are human beings with their own backgrounds and assumptions, and they can be mistaken. They will say that political prominence sometimes generates a level of legal scrutiny that differs from the treatment received by ordinary defendants. There is some evidence for this as well. But these defenses fall short when applied to the specific facts of the Engoron confrontation. Telling a sitting judge that the proceedings are boring to him is not a legitimate expression of frustration. It is personal condescension. Requiring multiple control-your-client directives across multiple courtroom appearances is not a pattern explained by judicial unfairness. It is a pattern that reflects a defendant who refuses to adjust his behavior to the requirements of the venue. Skipping court sessions to hold press conferences attacking the judge is not political prominence generating scrutiny. It is a defendant prioritizing political messaging over legal obligation. And attacking one's own judicial appointees as a disgrace is not reasonable criticism of judicial reasoning. It is a repudiation of the principle that judges should exercise independent judgment rather than personal loyalty. The cumulative weight of these facts tells a story that the defenses cannot adequately address. It is the story of a defendant who has made a strategic decision to treat the legal system as an extension of the political battlefield. The courtroom shutdown is a significant moment in that story because it captures the precise moment when the strategy collided with an immovable institutional barrier. The judge said no. The defendant kept talking. The judge said, "Control your client." The defendant kept talking. The judge imposed a 1-minute limit, then cut him off and recessed. The defendant walked out and held a press conference. The pattern is clear, and it is not a pattern that strengthens the rule of law. What comes next for American legal accountability in the face of this sustained challenge depends on whether the accumulated institutional responses will prove sufficient to uphold the standards that make the legal system function.